On September 19, 2024, an unidentified individual filed a petition for a domestic abuse injunction, commonly known as a restraining order, against respondent Lee Moritz in the Burnett County Circuit Court in Wisconsin under Section 813.12 of the Wisconsin statutes. A domestic abuse injunction is a civil order issued by a court to protect an adult from violence, threats, or harassment by a spouse, former spouse, dating partner, household member, or other qualifying individual. The statute defines domestic abuse as including intentional infliction of physical pain or injury, intentional impairment of physical condition, sexual assault, stalking, or threats. To take any of these actions, a petitioner can request a temporary restraining order, which may be granted the same day based on sworn allegations, followed by a hearing where the court determines whether to issue an injunction for a longer period of time. In Mr. Moritz's case, the petitioner obtained a temporary restraining order, and the court scheduled a hearing for October 10, 2024. Only the petitioner appeared on the scheduled date. Mr. Moritz did not come to court because he failed to appear. A domestic abuse injunction was issued based solely on the petitioner's allegations, without Mr. Moritz having the opportunity to test them. The injunction prohibited him from having any contact with the petitioner. For 4 years, Mr. Moritz later violated the injunction by reaching out to the petitioner multiple times. On August 1, 2025, Mr. Moritz was charged with violating a domestic abuse order in violation of subsection 8 of Section 813.12 of the Wisconsin statutes, which makes it a misdemeanor offense to knowingly violate a domestic abuse temporary restraining order or injunction. Mr. Moritz made an initial appearance on the charge on August 27, 2025, representing himself and entering a guilty plea. A status conference was scheduled for October 13, 2025. However, on October 1, 2025, Mr. Moritz was charged with another count of knowingly violating a domestic abuse order, along with a separate misdemeanor violation of Section 940.44 of the Wisconsin statutes. Criminalizes persuading or attempting to persuade the victim of any crime. From reporting the offense to law enforcement, a prosecuting agency, or a judge, Mr. Moritz's initial appearance for the second set of charges was scheduled for October 13th, the same date as the status conference for the first charge. Mr. Moritz appeared on that date in Judge Melissa Logan's courtroom. Lee Moritz. We will go on the record in the matter. State of Wisconsin versus Lee Moritz. The state appears through Assistant District Attorney Jose Vila in person. We have Mr. Morris in person without counsel. We're set today in these matters for an initial appearance in the 185 case and a status in the other. Mr. Morris, did you receive a copy of that new complaint? And that's what it looks like in your hand, yes. Did you read it? I didn't read the whole thing. But do you understand that charge and that maximum penalty? I really don't. Okay, it's easy. I'll just go over with you and you'll totally understand. It's alleging that on or around June 13th, 2025, you did so understandingly that you violated an injunction, which is a restraining order as people know it in lay terms, an injunction where you're not supposed to have any contact at all, in any way, shape, or form at all, with an individual in 24 cm 120. So they're alleging on June 13th, 2025, you violated that, you broke the law, you had contact, don't say a word, You could, upon conviction, you could be fined not more than $10,000 and have incarceration of not more than 9 months in jail. So that's that maximum penalty associated with the charge and what the state would have to prove. And it's alleging that you did have contact. You knew you had contact and you knew you weren't supposed to have contact with that domestic abuse injunction, okay? I would not say any facts about the case, because anything that you say here today can be used against you, okay? But if you have a question, an administrative question, I can answer that I spoke to Jose and he didn't help me at all. I had a lot he's not supposed to. He's on the opposite side. Oh, I see. I don't know how this works, okay? I have no idea how this works. He's the attorney that prosecutes you that doesn't want that. He's wanting to protect the public interest. And the allegations in both of these complaints, because they're very similar, so he's not the guy who can help you. Oh, if you're looking, I don't understand how any of this works, okay? So I don't have enough money to buy an attorney right now. So did you talk to? There was a gentleman and I'm going to try and find somebody outside who can stop Hey, why don't you please one of you run up? Mr. Flisky's right outside, and then we can get Mr. Flisky so he can talk with Mr. Morris to see if he qualifies. Thank you, miss. You talked to him already? I talked to a woman the last time I was here. Okay, and I don't qualify? I don't qualify at all qualify. So, but thank you. Miss Power, okay, so you don't qualify well. She told me I can only make like $200 a month, and I know. It's not that it's not $200 a month. It's like you probably own property. If you own property, I do, then that's what I own, quite a bit of property. So what you would probably like to do is retain your own attorney or apply for a court-appointed attorney. But that's still at your cost, and you'll still need to have money down. But if that's the route you wish to go, then you need to go outside and get that application. When we're done here today, fill it out today. It can't be any later to today. Because I'm not going to wait until the next hearing to have you go, I didn't do it, so you have to go fill that out today. If you want a court-appointed attorney at your cost, it's $100 an hour. But that's far less than the other attorneys. You can pay $300 or $400 an hour for a private attorney. You can go that route too. That's totally up to you. But otherwise, it's a reduced rate at $100 an hour. Having these cases, you would need to pay $350 down. I don't have any money, Your Honor, okay? So at this time, you're representing yourself, and that's fine, and you can do that, Judge Morgan explains. The court-appointed attorney process to Mr. Morris, and he states that he doesn't have any money. Under Wisconsin law, eligibility for a public defender is determined by the financial standards set out in Rule PD 3.03 of the Wisconsin Administrative Code. The requirements consider both income and assets to decide whether a defendant can reasonably afford private counsel, even though a defendant like Mr. Moritz, who has limited income, may appear indigent. Rule PD 3.03 requires the agency to consider the equity value of the applicant's assets, such as real estate vehicles or other property, and treat those resources as available to pay attorney fees. In most cases, an applicant is ineligible if the combined equity value of their assets exceeds $2,500 after excluding up to $10,000 in equity value of vehicles, and the first $30,000 of the equity value of the home that serves as the individual's homestead. Here, Mr. Moritz owns property with equity above that threshold, meaning that despite having limited cash funds, he does not meet the asset-based indigency requirements, and therefore does not qualify for a public defender. Not guilty plea is going to be entered on your behalf on this charge, as well as the last charge. But Mr. Villa, you're not his attorney. You don't represent him. He tried to talk to you about the case, so with regards to this matter and your boots that you feel, what is an offer that can be presented? Your Honor, at this time, I cannot present an offer. We have further cases that are coming down the pipeline, so I'm going to do a global. Okay, so there's more referrals of the same issue. Yes, Your Honor. Okay, so you can understand, Mr. Morris, from what Mr. Villa is saying, is that there are more allegations of you doing the very same thing. And it looks like more charges. More cases are coming down the pike, okay? So it's all Greek to me. All I can say is I can strongly advise you that you need to not have any contact. Not only because it's criminally hurtful, but because you have a domestic abuse injunction. 0 contact with BR, 0 contact. No texting, no talking. No swearing, no pushing. No third-party contact unless it's through an attorney. Prosecutor Jose Villard informs Judge Morgan that the state is not prepared to offer Mr. Moritz a plea bargain at this time because additional charges are still being processed. In response, Judge Morgan strongly advises Mr. Moritz to avoid any further contact with the petitioner, reminding him that the existing domestic abuse injunction requires him to have no contact whatsoever. As we discussed earlier in this episode, each separate communication can constitute a new violation of Section 8.13.12 of the Wisconsin statutes, which criminalizes knowingly violating a domestic abuse injunction. By warning Mr. Moritz to avoid contact with the petitioner, Judge Morgan is effectively trying to prevent him from accumulating even more criminal charges. While his current case is pending, can I talk to you? I may not be able to give you any answers. This is my situation. I don't know if you want to tell me your situation because, again, I want you to understand everything. I can't understand everything that you say can be used against this gentleman right over here. And he can use it, and he can use it even if it hurts you. But I need to talk to her because she did all my business work, all my taxes, and I need some documents from her to get. I can't, but I need that, and she will not give me. That's why I would stop. I would stop right now, because I just don't understand what's happening. I didn't abuse anybody. I've never abused anybody in my life, but there is a domestic abuse injunction. That's a false allegation. Well, it's in effect because she came to the court first. I'm telling you right now, I'm not going to go look at the case. I'm not going to look at the facts. I'm not going to do those things. There is in effect a domestic abuse injunction that says absolutely zero contact. None whatsoever, no text messages. No calls, no thinking hypothetically or not hypothetically thinking. Towards her, no talking to people. Not trying to do anything that has any contact with BR at all. Not at all. And if you need contact, you want to know, it says in the injunction. I can tell you right this because it says in the injunction, you can have zero third-party contact unless it's through an attorney. So that's your option. I don't have any money. So my life's in your hands, Your Honor. It's not in my hands, it's in your hands. Because I don't make the choices and I don't have the conduct. You do, you're the one who understands what the law is prohibiting. And you continue to do it the only way. And through that injunction, it says attorney. So what you're gonna need to do is, I'm strongly advising you, at least you can go hire an attorney for this one sole little thing. I don't have any money, Your Honor, I don't. She took $25,000 from me and split. I don't know what else to tell you. I don't have any money, so I don't want to go to jail. I don't know what to do. I would stop having contact with BR. But I need some paperwork from her. And I told you how to need it. I told you I can't afford an attorney. Your Honor, I'm at your mercy. There is no mercy here. I cannot be merciful. I have nothing that I can do right here at this time. An injunction says zero contact anyway. Shape or form. I understand except through an attorney. So you know the fix, I understand. And you have the fix, you just have to figure out. Problem solved to get that, to be able to get what you need. I can't give you authority to do that. I understand what I'm going to do. How long do you think it's going to take you to review these new referrals? Your Honor, less than 30 days. December 10th at 9:45, December 10th at 9:45. We're going to have the next hearing, and that's a status, and most likely it's going to be further initial appearances again. All I can say is from the injunction, Mr. Moritz, and I'm trying to tell you your path and the thing that you can do. You need an attorney to just have that communication. And I know you say you don't have money, but here's the thing. Have you talked to an attorney to see how much money it'll cost just to have that communication? $15 retainer? Well, how many attorneys did you talk to, Benson? Oh, one. There's multiple other attorneys to talk to that don't charge $15 retainer just to send a letter to try and get business documents. There's more than one attorney in the world, okay? As you saw, we had at least 4 in here today. Not counting the state, Mr. Villa, Your Honor. It does appear that we also need to set bond for these cases, all right? The court is going to do $500 signature bond, okay? $500 signature bond, absolutely no contact with BR or residents. I have a question, yes. What does a signature bond mean? A signature bond means you're going to sign the bond. You're going to understand the conditions. You come to court, you follow the law. You don't break any of the conditions. If you do, great, and you don't violate any of those things, then you're fine. You're just signing by your signature. You're saying, I'm agreeing to abide by this. If you violate, not only can the court convert that to cash, we'll have to pay $500 bail, but the state has the ability to charge you for what's called bail jumping, okay? So you're charged with misdemeanor. So if you violate anything, I sign this bond, and if I don't communicate at all, I don't have to pay money. I don't understand, correct? You don't violate the bond. So what do I sign that today? Yes, you'll come up here and sign it right here today, okay? Judge Morgan informs Mr. Moritz that he will be released on a $500 signature bond under Section 969.02 of the Wisconsin statute. Courts have several options for releasing misdemeanor offenders, including what the statute refers to as an unsecured appearance bond. The formal term for a signature bond, this type of bond does not require the defendant to post cash or secure sureties instead. The defendant signs a written promise to appear in court and agrees to owe the specified amount only if he fails to appear or violates any condition of release. In practical terms, the $500 is not paid up front. It becomes due only if Mr. Moritz breaches the terms of his bond. Furthermore, if Mr. Moritz violates any bond conditions, such as by continuing to contact the petitioner, he may face an additional criminal charge for bail jumping under Section 946.49, which makes it a separate offense to intentionally fail to comply with the conditions of a bond. I wrongly encourage you to either find an attorney and retain that attorney, or to apply for that court-appointed attorney. Okay, and you'll fill out the whole application. But I need proof of your income as well as... I don't have it because I don't have the documents. Don't need those documents. I just need you to tell me, I make this much and this is under perjury. So I make this much a month? I don't make a steady income. I've been self-employed since 1997. I understand you used to cut our grass here. Yes, I understand that. I did, and I lost my job because of this whole situation of false allegations. Mr. Moritz, I don't understand any of this. I've never been in trouble with the law. Here's the thing. You know people who know about the law. I know that, so go talk to people who know about the law. And either apply for a court-appointed attorney. That's an option right there. And you don't even have to say I don't need to know. I make $100 this month, I make $300. Well, that's the thing, it all depends on the weather. If it rains, I mow. If it snows, I plow. If it doesn't rain or snow, I don't make any money. You have an idea. You have an idea of how much you make, okay? You have an idea I don't make enough to pay my mortgage right now. It's been dry for 6 years. Then it sounds like you could look at other employment opportunities as well, but here's the thing. I'm 49 years old. I'm not going to argue with you. I don't want to argue. Just then stop. I just want to go home. I gave you my options. You have those options. You need to choose one of those options because it sounds like it's going to get a little bit deeper. Because the state has more referrals. I don't know how many, but it could be 2 or more cases. 2 more referrals. I text a couple times. An injunction means no contact, none. I understand. What if she contacts me, though, and I'm not allowed to contact? Ignore it. Can you make sure there's no contact on the phone? That's what I said, okay? That's what I meant. If she contacts you, you do not even respond. I can't talk to you because that's violating. Sounds like it's a, kinda lopsided. Why can't she contact you and you can't contact her? That's what I don't understand because it's the law. See, I don't understand the law. I'm not a judge, I'm not a lawyer locker. But I need that paperwork. Here's the thing. Again, the only reason why I know this is because you brought your sister with you at the last hearing. That your sister is a law enforcement officer. Somebody to talk to who knows the law. She knows the law. She's an officer of over 20-some years. Maybe 30. She's an officer 30 years. So talk to your sister, and again, I only know that from the last hearing you were here, so you can't be trying to wishy-washy. Tell me you don't understand the law. You don't know the law, I don't. An expert, a law enforcement officer. She can tell you all the things she doesn't. She's not a lawyer, she's a police officer who knows the law. And if you say, hey, sister, I have a domestic abuse injunction against me with BR, does that mean I can't contact her? The thing is, it's false allegations. That's not justice, okay? It's all false allegation, okay? Again, I just want to go home. I'm correct. No, you don't want to just go home. You want to continue to argue and to argue and to argue. And to argue and to argue. So stop, because I'm not going to do this again. You're getting your one time right now to have your voice be heard, and that's it. Thank you for letting me be heard. And I understand you have these issues, but I can't tell you what to do. Only an attorney can tell you what to do and how to go about it. I've given you your options, okay? Thank you, so come and get your notice. Thank you, Your Honor. We'll see you in December. It's not a waste of time, it's my job, because Mr. Viard indicated that additional charges were likely. Judge Morgan scheduled another status conference for December 10th, 2025, and on October 21st, 2025, another charge of knowingly violating a domestic abuse order was filed. Mr. Moritz made his initial appearance on November 5th, where he pleaded not guilty, and as of the date of writing this episode, a status conference for all pending charges remains scheduled for December 10th, 2025. This hearing highlights how a defendant's outlook and decision-making can directly shape the trajectory of a criminal case. Throughout the proceeding, Mr. Morris adopted a persistently defeatist tone, insisting that he had no money, could not understand the law, had been treated unfairly during the restraining order process, and had no choice but to contact the petitioner. Rather than engaging with Judge Morgan's repeated attempts to outline practical solutions, including the straightforward guidance that any communication with the petitioner must occur only through an attorney, Mr. Moritz responded by reiterating why he believed that none of those options applied to him, even when the court explained that his property holdings placed him outside the public defender eligibility guidelines. He made no effort to consider how those same assets could be used to secure counsel or otherwise address his situation in a lawful way. Judge Morgan repeatedly attempted to show Mr. Moritz a path forward, but each time she provided a means for Mr. Moritz to improve his situation, he answered with another reason about why it could not be done. In the end, Mr. Moritz's circumstances were difficult, but his own refusal to take accountability, explore solutions, or adjust his behavior actively prevented him from finding his way out of a bad situation, and even caused him to accrue additional criminal charges. This case ultimately demonstrates that, while courts can offer limited guidance, the responsibility for shaping a defendant's future still rests with them, and here, Mr. Morris repeatedly chose the path that placed him at greater legal risk, rather than the one that could have helped him move forward. Let us know if there is a case or courtroom interaction that you'd like us to explore in the comments down below. Thank you for watching, and don't forget to like and subscribe so that we can help foster a more informed society.